So I'm just going to admit that I never thought I'd see the day where there would be broad interest in learning about qualified immunity, but here we are. So given that there are efforts underway to try to persuade legislatures and Congress to eliminate qualified immunity, it might be helpful to understand what qualified immunity is in the first place, right? And so in order to understand what qualified immunity is, it's probably helpful to know what it actually applies to. There is a federal civil rights statute, 42 USC section 1983. Usually you'll just hear it referred to as section 1983, that permits individuals to bring civil actions against state actors who they believe have violated their constitutional rights. So pertinent to the discussions you're hearing this summer, if you as an individual think that police officers have used force when they shouldn't have, excessive force, unreasonable force in an encounter with you, force that would be considered unreasonable under the Fourth Amendment, you can bring a Section 1983 lawsuit challenging that use of force as unconstitutional. And this is one of the major ways in which people litigate police use of force. There usually isn't an avenue to do so in criminal cases. It's not generally going to be a defense or any sort of claim really you can raise in the context of a criminal trial. And of course, there are a lot of people who never get anywhere near a criminal trial or even criminal charges who believe that police officers have used unreasonable force against them in other kinds of encounters. And so oftentimes this is one of the major ways where you would litigate police use of force. There are also, of course, state tort law claims you might be able to file and other kinds of claims. But this is a pretty major way in which people will challenge police use of force. So qualified immunity is the doctrine that says if you're a police officer, it's not enough that a litigant demonstrates that you used unconstitutional force. They also have to demonstrate that it was clearly established that that force was unconstitutional. So if you're a plaintiff, it's really kind of two steps, right? You have to show that the police officer's behavior was unconstitutional, and also essentially that they should have been on notice about that because it was already clearly established that using that kind of force was unconstitutional. So what are the possible problems with that? Well, one, at least as many courts have interpreted qualified immunity, they've decided that in order for you to succeed on the second part of that, demonstrating that the law is clearly established, that you basically need to be able to find another case where police officers use the same kind of force under the same sort of circumstances. And oftentimes courts are really very fact specific, right? This occurred in a ravine as opposed to in a river. Well, it's not clearly established. You can't use the particular form of force on dry land, right? And so oftentimes courts will really struggle to distinguish prior cases and say, look, on these facts, the use of force was not clearly established to be unconstitutional. So that's one critique of qualified immunity. It's often very difficult, even if you think that the police officer's behavior is unconstitutional and outrageous, it's often very difficult to find the matching case. The other thing is that the Supreme Court has said you don't have to walk through those two prongs in that order. In other words, the court doesn't have to first consider, is the officer's behavior unconstitutional, and then decide, now that I've decided it's unconstitutional, do I think it was clearly established that the officer's behavior was unconstitutional? They can just start with the second prong and end there. So if it's not clearly established that the officer's behavior was unconstitutional, qualified immunity protects them and they cannot be held liable. What that means is oftentimes courts never answer the question, is this behavior unconstitutional in the first place, which means it's very difficult to create the case law that clearly establishes that a particular circumstance where police officers used force or a particular way in which they used force was unreasonable. So those are some of the critiques of the doctrine. What is going on with it right now? Well, a lot of people are urging Congress to get rid of qualified immunity, either for police officers specifically or for state actors more broadly. And the question that I've been asked by a number of folks is, well, can Congress do that? And the answer is Congress absolutely could. qualified immunity is a judicially created doctrine. In other words, the Supreme Court hasn't said it's constitutionally required. It's not rooted in a statute that Congress has passed. There's nowhere a statute that's going to tell you police officers or other state actors are protected by this kind of immunity. So it really is a legislative decision if the legislature wants to rescind qualified immunity. Another thing, of course, that could happen is that the Supreme Court could decide to modify, limit, or eliminate qualified immunity. And this is one of those interesting circumstances where the people on the Supreme Court who are most quizzical about qualified immunity are actually at polar ends of what I think oftentimes people think of as the spectrum of the court. So the two most skeptical justices actually are Justice Thomas, who says it's not in the statute, it's not required by the Constitution, I don't understand why we have this doctrine in the first place, and Justice Sotomayor saying those things, absolutely, and also this is leading to absurd results that we're just not required to be finding because Congress didn't tell us we had to do this in the first place. So that's qualified immunity. If you want to understand a little bit more about how it applies to police use of force, it might be helpful to also watch the video on how the Fourth Amendment constrains police use of force.